Hi, beautiful people. You're welcome to my space, my learning space. Now, we all know that the past few days has been really hot in Nigeria. The past few days has been really hot in Nigeria. Now, we know the president declared a state of emergency in Rivers State and went further to suspend the governor, the deputy governor. Now, the thing there is, I am not saying what the president did is right. I am not saying what the president did is wrong. I am bringing to us our constitution. Now we hear what the constitution is saying. So we'll be looking at the 1999 constitution of the Federal Republic of Nigeria as amended. Let's get started. Now, let's take a walk to section 1 sub 1 of the 1999 constitution. Now, it says that this constitution is supreme and its provisions is binding on all persons. This constitution is supreme and its provisions is binding on all persons. So that is to say, so far you are a citizen of Nigeria, the provisions of the constitution is binding on you. Just for the fact that you are a citizen of Nigeria, the provisions of the constitution is binding on you. And there is no segregation by title or by whatever power you wield or whatever position you're holding. There is no segregation. The constitution is binding on you. That is how powerful our constitution is. Now, let's get started into today's lesson. Firstly, we are looking at state of emergency. We're just looking at two main things. Firstly, state of emergency. We are looking at when should a state of emergency be declared in a state or in Nigeria. When? That's the first thing we're looking at. Secondly, we are now looking at the suspension of the governor and his deputy. Is the suspension of the governor and his deputy right? Is it what the law expects? Is it what our constitution expects? Now, if it is not right, what is the due process for removing an elected official? And our case reference will be made specifically for the governor and his deputy. What are the processes involved? If the constitution is saying, oh, the suspension is wrong, now what are the processes for removing an elected official? And we are making this reference to the governor and deputy governor. So just sit tight and enjoy the lesson. Now, section 305, subsection 1 empowers the president to declare a state of emergency. He has the right, by virtue of section 305, subsection 1, he has the right as the president to declare a state of emergency in Nigeria or any part thereof. Now, when we talk about or any part thereof, that phrase simply means in any state at all. So far, that state is a state that makes up the country Nigeria. The president has the right to declare a state of emergency. It is an express power. However, in subsection 3, that is section 305, subsection 3 of the 1999 constitution as amended, in subsection 3, it goes further to state the conditions or the things that must be present before a state of emergency can be declared. Now, section 305 sub 1 is more like an express power, empowering the president to declare a state of emergency. Now, 305 sub 3 is more like taming that power. It's more like telling the president, you have the power, yes, but it's not an absolute power. You cannot wake up and say, I want to declare a state of emergency in Borno State, and then it prevails. It's like it tames that power that has been given to him. It tames that power, saying these are the things that must be present before a state of emergency can be declared. Now, what are those things? Number one, when there is war in the federation, and by federation we mean Nigeria, when there is war in Nigeria, the president has the right to declare a state of emergency. When there is war in Nigeria, he has the right to declare a state of emergency. Secondly, when there is imminent danger of invasion or war in Nigeria, paragraph C says, when there is a breakdown of public order and public safety, which ordinarily measures, legal measures, have not been able to curtail it. There is breakdown of public order and public safety, and legal measures have been put in place to curtail it, but it has not been possible to restore peace. It's saying the president can declare a state of emergency. The president can declare a state of emergency. Also, when there is clear danger in Nigeria or any part thereof, the president has the right to declare a state of emergency. Also, the next one is when there is presence of natural disaster or natural calamity, the president can declare a state of emergency. When there is occurrence of natural disaster or calamity, he has the right to declare a state of emergency. Also, when there is public danger, now this danger that is occurring presently is a threat to the existence of Nigeria. Remember, Nigeria is not Nigeria. Nigeria is Nigeria because of the existence of various states. Now, when there is a threat, when there is public danger that poses as a threat to the existence of Nigeria, the president can declare a state of emergency. When the governor of a state requests the president to declare a state of emergency in his state, no, this request must be backed up by the resolution passed by members of the State House of Assembly. Now, one thing we should know is a state of emergency does not warrant anybody to suspend the governor or his deputy. A state of emergency does not warrant anybody to suspend the governor or his deputy. That there is an ongoing state of emergency or the president has declared a state of emergency does not warrant the suspension of a governor or a deputy. Let's go to section 11, subsection 4 of the 1999 Constitution. Section 11, subsection 4 of the 1999 Constitution provides that when there is a state of emergency ongoing in a state, the National Assembly has no right to remove a governor or a deputy governor. The National Assembly don't have that power. The National Assembly, they don't have that power when there is an ongoing state of emergency. It doesn't give anybody the power to remove a governor or a deputy governor. Now, if there is an ongoing state of emergency and the National Assembly cannot remove a governor or deputy governor, now who can remove the governor or deputy governor? Section 188, Section 188 of the 1999 Constitution provides that only the State House of Assembly has the right to remove a governor. Now, what are the processes involved? What are the processes involved? Because there are laid down processes. Now, what are the processes involved in the removal or in the impeachment of a sitting governor or his deputy? Now, what is the process? The first step in that process is this, that a written allegation signed by one-third of the members of the State House of Assembly is brought, a written notice of allegation stating that the holder of this office, that is the holder of the office of the governor or the deputy governor, is guilty of gross misconduct. One-third of the members of the State House of Assembly brings a written notice of allegation that the holder of this office is guilty of gross misconduct. That is the first step. That is the first step. Now, the next step is this. When this written notice of allegation is brought, remember, it must be signed by at least one-third. It can be more than one-third, but it must not be below one-third of the members of the State House of Assembly. Now, when this written notice of allegation is brought, the law says, the Constitution says, The Speaker of the State House of Assembly shall, within 7 days, this written notice of allegation has been brought. Remember, it must be signed by at least 1/3 of the members of the State House of Assembly. Now, once it is brought, the allegation shall contain the particulars. It's not just saying the holder of this office is guilty of gross misconduct. No, it must specify the particulars of that allegation. It's not just enough to say we want to remove this person. No, the particulars must be contained. The particulars of that offense, that gross misconduct, must be contained therein. Now, once the Speaker receives that notice, the law says that the Speaker shall, within 7 days, cause this notice to be served to the person, the holder of the office, whose impeachment process has begun. So the first step to that process is the notice of allegation signed by 1/3 of the members of the House of Assembly, specifying the gross misconduct and its particulars. The second step is the Speaker shall, within 7 days, cause that allegation, that written notice, to be served to that person. Now, once it is served to this person, that is, for example, the deputy governor, once it is served to him, he has the right to reply. Now, where he decides to reply, he's replying to that notice that has been served to him. Where he decides to reply, his reply, on that reply getting to the Speaker, the Speaker shall cause that reply to be served on each member of the State House of Assembly. So that means even if there are 1,000 members, even if there are 1,000 persons that make up the State House of Assembly, that reply must be served on the 1,000 members, not just on the 1/3 that signed that notice. That reply will be served on all the members of the State House of Assembly. It will be served on all of them. Which reply are we talking about? The reply the deputy governor made. The reply he made in response to that notice of allegation. Now, the law provides, our constitution, remember, provides that within 14 days of the Speaker receiving that notice, remember, the first step is a notice is brought, signed by at least 1/3 of the members of the House of Assembly, that State House of Assembly. Now, that notice is served on the holder of that office. Now, the holder of the office can decide to make a reply, that's a statement in reply. Now, when that statement in reply is made, the Speaker will cause that statement to be served on each member of the State House of Assembly. Now, after that, within 14 days of receiving that notice, now the law provides that within 14 days of the Speaker receiving that notice, of allegation, now it will be brought to the House for them to move a motion whether it should be investigated or not. A motion will be moved. Should we investigate this allegation that has been brought or not? When that motion is moved and the House is of the view that the allegation must be investigated, 2/3 majority of the House, 2/3 majority of the State House of Assembly must consent to the investigation. Allegation is brought. Within 7 days, it is served on the holder of the office. Within 14 days, a motion will be moved for the allegation to be investigated or not. Now, where 2/3 majority of the House states that this allegation must be investigated, the Chief Judge, at the request of the Speaker of the State House of Assembly, will appoint a 7-man panel. The two conditions the Constitution provides that must be present before a person is eligible to be a member of that 7-man panel. Now, this 7-man panel is to investigate. They are to do what? Investigate this allegation that has been brought. A hearing starts. The next step is hearing. Now, hearing has started. Now, the governor or the deputy governor, he has the right to defend himself. Now, where he decides, I don't want to defend myself, he has the right to seek the services of his legal practitioner. He has the right to a lawyer to defend him. He has the right of defense by a legal practitioner. Now, within 3 months, of that 7-man panel that has been created by the chief judge at the request of the speaker, within 3 months, that 7-man panel will bring their reports. Within 3 months, they'll bring their reports, their findings. Now, when that report is brought, the report is now being looked at. Now, let's look at two things. Where the report provides that, oh, this person is not guilty of this. This person is not guilty of this gross misconduct that he's been alleged to have committed. He's not guilty of it. That ends the whole case. That ends the matter. That ends the whole case. Where the report states that he is not guilty. Remember, the 7-man panel, they are the ones that did the investigation. So, from the reports of the investigation, this person is not guilty of this offense. Case has closed. It ends there. Now, however, where the allegation is proved, the 7-man panel, they've done the investigation. Now, the report they are bringing to the house is saying this deputy governor is guilty of this. There is proof. The allegation is proved. The next step is what? Adoption. Adoption of that report. Adoption of that report. Where the allegation is proved, within 14 days, the State House of Assembly will consider the report and move to adoption. The Constitution provides that 2/3 majority of the House must adopt the report. 2/3 majority must adopt. That is, adopting is they are in support of this report. They are in support of the findings from this investigation that has been done. They are in support. Now, where 2/3 majority of the House adopts this report, from the moment of adoption, from that point in time where that report is adopted, the holder of that office stands removed. And where 2/3 of the majority has adopted that report and the person is removed from office, he cannot challenge his removal in any court of law. Now, we have heard from our law, the 1999 Constitution. Now, let's discuss as persons that have heard from our Constitution. You did not hear anything from me, you heard from the Constitution. Now, let's discuss as persons that have heard from the Constitution. Do you think that the suspension of the governor and his deputy is right? And I guess we all have learned one or two things. At least I know I tried to break things down. But don't forget to still send in your questions, just in case you feel lost somewhere, you did not just quite understand what I just said, or oh, this is sounding so foreign, it's sounding like a foreign language. It's fine. Send in your questions, and I'll be glad to attend to them. And also, don't forget to also send in your comments and your suggestions. You have one, because Nigeria is for all of us. We are the people that make up Nigeria. So we are all Nigerians. Nigeria is for us all. Nigeria is for all of us. But don't forget to send in your own supporting law. Maybe there is a section of the law, even if it might not be the Constitution. There's another law that is supporting the action that was taken. Please don't forget to send it in with your comment. Don't forget to say, okay, this law supports this action in section this, or you have a judicial precedent that supports this action. Please don't forget to send it in. Remember, we are all here to learn, and I'll be willing and I'm ever ready to learn from you, my audience. I love you all, and don't forget, I want to see you all succeed. I love you all. Bye for now.